If you think you're safe because you heard a video say gun permits are over nationwide after a new court ruling, I need you to hear what I'm about to say very carefully, because the claim is partly true and mostly dangerous. If you are in one of the 21 states that still legally require a concealed carry permit, and you start carrying without one because you believe the law has changed, you could be arrested and charged with a felony depending on your state. Not a fine. A felony that could permanently strip your right to own firearms for life. No viral video title protects you from that. No court ruling that does not actually exist protects you from that. So let me give you the complete, accurate picture of where permit law actually stands in America in June 2026. Subscribe right now because every gun owner in America needs to understand this correctly. Here is the part of the claim that is real. Gun permits have genuinely been eliminated in 29 states. That number represents a transformation of American gun law that has happened over 16 years and is one of the most significant expansions of Second Amendment rights in the nation's history. In 2010, only 2 states had what is called constitutional carry or permitless carry. Those were Vermont, which never required a permit, and Alaska, which eliminated the requirement in 2003. By 2026, 29 states allow law-abiding adults to carry a concealed firearm without a government-issued permit. That is more than half the country. And the list includes major states like Texas, Florida, Georgia, Tennessee, Ohio, Oklahoma, and Missouri. In those 29 states, the title is accurate. Carry permits are over. You do not need one to carry concealed. You just need to be legally able to possess a firearm under state and federal law. But here is what the viral title gets dangerously wrong. That is 29 states, not 50. The other 21 states still require permits, and those 21 states include California, New York, New Jersey, Illinois, Maryland, Massachusetts, Connecticut, Delaware, Rhode Island, Michigan, Minnesota, New Mexico, Nebraska, and others. Some of these are the most densely populated states in the country. If you add up the population of the 21 permit-required states, you're talking about more than 150 million Americans who still live under a system where carrying concealed without a permit is a crime. The viral version of this story does not tell you that. It tells you permits are over. And then those 150 million people in permit-required states sometimes act on that belief. And sometimes they get arrested, and sometimes they are charged with felonies that end their gun rights permanently. If you are finding this important, subscribe right now. Because the legal landscape for gun owners is changing fast, and the difference between accurate information and viral misinformation is the difference between exercising your rights and losing them. Let me explain how we got to 29 states because the history matters for understanding where we are going. Constitutional carry began as a fringe legal theory. The idea was simple. The Second Amendment says the right to keep and bear arms shall not be infringed. Requiring a permit before you can bear arms is an infringement. Therefore, permit requirements are unconstitutional. Vermont had always operated this way by long-standing state practice. Alaska was the first modern state to legislatively adopt permitless carry in 2003, then nothing for several years. Arizona followed in 2010, Wyoming in 2011. Then the movement accelerated after the Supreme Court's 2008 decision in District of Columbia versus Heller, which confirmed that the Second Amendment protects an individual right to keep and bear arms for self-defense. State legislatures and gun rights. Friendly states began asking, if there is an individual right to bear arms, why do we require people to pay for permission to exercise it? The political answer drove the legal change. Arkansas in 2013, Kansas in 2015, Mississippi in 2015, Idaho in 2016, Missouri in 2017. Vermont updated its law to add formal recognition in 2018. And then the movement went mainstream. Between 2019 and 2023, more than 20 states adopted constitutional carry. Texas in 2021. Georgia in 2022, Indiana in 2022, Alabama in 2023, Louisiana in 2024, and the trend continues. Now let me explain the crucial legal distinction that the viral content almost never gets right. Constitutional carry in each of the 29 states means that a person who can legally possess a firearm under that state's law and under federal law does not need a state-issued permit to carry concealed in that state. That is all it means. It does not mean you can carry in sensitive places like schools, government buildings, or anywhere a sign prohibits it. It does not mean your permitless carry right travels with you when you cross state lines. It does not mean the federal restrictions on who can possess a firearm have changed. And it does not mean permits have become useless. Let me explain each of those points because they are all critical. First, your state's constitutional carry law only applies in your state. If you live in Texas, which has constitutional carry, and you drive to California, which requires a permit, you cannot carry in California without a California permit, or a permit that California recognizes through reciprocity. Texas's permitless carry law only operates in Texas. You are governed by the carry law of whatever state you are physically standing in. This is the most misunderstood aspect of constitutional carry. The phrase makes it sound like a universal right. Legally, it is a state-specific policy that governs carry within that state's borders. Second, even in constitutional carry states, sensitive places restrictions still apply. You cannot carry in schools under any state's law without specific authorization. You cannot carry in federal buildings. You cannot carry in courthouses. You cannot carry in places specifically posted as no carry zones. These restrictions exist whether or not your state requires a permit. Third, even in constitutional carry states, federal restrictions still apply. If you are a convicted felon, if you have a qualifying domestic violence conviction, if you are subject to a qualifying restraining order, if you are an unlawful drug user, you cannot carry a firearm in any state regardless of that state's permit law. Constitutional carry eliminates the permit requirement for people who can legally possess firearms. It does not change who can legally possess them. Hey, 73% of people watching right now are not subscribed. I am about to tell you something that even many gun owners in constitutional carry states do not know, and it could protect you from a federal charge. Subscribe right now. Fourth, and this is the critical point that even many gun owners in constitutional carry states get wrong, permits are not useless in those states. They provide real, concrete legal benefits that permitless carry does not. Here is the biggest one. The Federal Gun-Free School Zones Act makes it a federal crime to knowingly possess a firearm in a school zone, which is defined as within 1,000 feet of a school. The GFSZA includes an exemption for licensed gun owners who have a permit issued by the state in which the school is located. But that exemption does not apply to permitless carriers. That means if you live in Texas, drive through a neighborhood within 1,000 feet of a school, and you are carrying on Texas's permitless carry authorization, you have no federal GFSZA exemption. If you have a Texas license to carry, you do have the exemption. The difference is a potential federal criminal charge. There is also the reciprocity benefit. If you have a state-issued permit from a state with broad reciprocity, like Florida, Texas, or Utah, that permit is recognized in 30 or more other states. Your permitless carry authorization from your home state is not recognized anywhere outside your home state. If you travel and want to carry legally, a permit gives you legal carry rights in a network of reciprocating states. Permitless carry gives you nothing outside your home state's borders. And then there is the practical benefit of training. Permit courses teach you the law of your state. They teach you the deadly force standards for self-defense. They teach you when you can legally draw and when you cannot. They put you through a range qualification that confirms your safe handling. In constitutional carry states, none of that is required, which means some people are carrying firearms without knowing when they can legally use them. Getting that wrong in a self-defense encounter does not just mean you face criminal charges. It means you face criminal charges while the other party's family is claiming you were the aggressor. Now let me tell you about the legislation that is actually pending in Congress that could affect permit requirements nationwide. Because the real change that the viral title is pretending already happened might actually be coming. Two bills are currently in Congress. The first is H.R. 38 and Senate Bill 65, the Constitutional Concealed Carry Reciprocity Act of 2025. I have covered this bill extensively on this channel. It would require every state to recognize valid concealed carry permits from every other state. This is the National Reciprocity Bill. If it passes, a Florida permit holder could carry in California. A Texas license holder could carry in New York. Every qualifying permit holder would have carry rights everywhere in the country. This bill has passed the House in previous sessions but has never become law. It is currently pending in the Senate Judiciary Committee. The second and more sweeping bill is the National Constitutional Carry Act, introduced by Senator Mike Lee. This bill goes much further than reciprocity. It would assert that the Second and 14th Amendments prohibit states from imposing criminal or civil penalties on lawful carriers from any state, and would effectively bar states from imposing permit requirements, fees, or other requirements that dissuade public carry. If this bill passed, it would be the closest thing to actually eliminating gun permits that the headline describes. But this bill has not passed. It has not had a markup or a hearing. It has been introduced and referred to committee. The political path to passage is extremely uncertain. As of June 2026, neither bill is law. Let me now connect all of this to the recent Supreme Court decisions that are actually changing the landscape. The Bruen decision in June 2022 is the most important case for understanding the permit question. Bruen struck down New York's may-issue permit system, which required applicants to show a specific need or proper cause to receive a carry permit. The court said that subjective discretionary permit systems violate the Second Amendment. States must have objective, shall-issue permit systems where anyone who meets defined criteria can receive a permit. After Bruen, the remaining may-issue states, California, Hawaii, Maryland, Massachusetts, New Jersey, quickly converted their laws to shall-issue systems. Connecticut and Delaware tried to maintain elements of may-issue, but the critical point is this. Bruen required objective shall-issue systems. It did not require states to eliminate permits. States still can and do require permits. They just cannot use subjective criteria to deny them. The June 25, 2026 ruling in Wolford v. Lopez struck down the vampire rule in Hawaii and 4 other states. I covered this decision extensively in a recent video. That decision is about where you can carry with a permit, not about whether you need one. It does not eliminate permit requirements. And the June 18, 2026 ruling in Himani is about the federal drug user gun ban, not about permit requirements at all. None of the recent decisions have eliminated permit requirements. The viral claim is simply wrong on the law. Here is what is actually happening right now. In the 29 constitutional carry states, you genuinely do not need a permit to carry concealed. That is a real and significant legal right. In the remaining 21 states, permits are still required. And 2 pieces of legislation in Congress could either force nationwide permit reciprocity or, if the Lee bill passes, effectively force the country toward permitless carry. Neither has passed. Watch them closely. When either passes, the story changes. Until then, carry legally based on the actual law of your state. Let me give you your specific action plan right now. Step 1. Find out if your state has constitutional carry. If it does, you may carry without a permit as long as you meet your state's eligibility requirements. But consider getting a permit anyway for the GFSZA exemption and out-of-state reciprocity. Step 2. If your state does not have constitutional carry, getting your permit is the single most important thing you can do for your legal protection. Know your state's process, cost, training requirements, and timeline. Step 3. If you travel across state lines with a firearm, get a permit from a reciprocity powerhouse state. Florida, Utah, and Texas permits are honored in the most states. A permit from one of these states dramatically expands your legal carry rights when traveling. Step 4. Regardless of your state's permit law, know the sensitive places rules. Schools, federal buildings, posted private property. These restrictions exist everywhere. Step 5. Take a training course even if your state does not require it. Understanding when you can legally use deadly force is not optional. Getting that wrong in a self-defense situation is a criminal disaster. Here's the bottom line. Gun permits are over in 29 states because those states decided, through their legislatures, to trust law-abiding adults with the constitutional right to carry without paperwork. That is a genuine and significant expansion of freedom. But 21 states still require permits. No court ruling has changed that for those 21 states. And carrying without a permit in a permit-required state is still a crime. Do not learn this lesson from a cop handing you a felony charge. Learn it here. Subscribe right now so you never miss an update when the law actually does change in your state or nationwide. And as always, this is educational content only, not legal advice. The carry laws of your specific state require guidance from a firearms attorney who knows that state's current requirements. Know your rights, know your state's rules, and carry legally.